If you're keeping track of the enforcement of Idaho's abortion laws, it's time to get out the editing pencil. For this segment, let's focus specifically on the application of Idaho's abortion laws in emergency situations. So the laws in the Gem State are pretty simple. Abortion's against the law except for cases of rape and incest that are reported to law enforcement or in situations where they need to save the life of a mother. So a federal court ruled about 2 weeks ago that Idaho's abortion ban can go into full effect. And that overturned a narrow pause on enforcement in emergency situations. You're looking at documents from September 28th and 29th, and that's when the Ninth Circuit Court of Appeals sided with the state and the state legislature in lifting a partial injunction of the abortion ban. And that's because of a challenge by the U.S. Department of Justice, the Biden administration. So they sued over the lack of exemption in Idaho law, as they say, to protect the health of the mother. So the Justice Department challenged Idaho law, saying it violates the Emergency Medical Treatment and Labor Act, or EMTALA. And that is a federal law that requires medical providers at facilities that receive Medicare funds to treat and stabilize anyone for an emergency. So in late September, Judge Lawrence Van Dyke wrote that the legislature made a strong case that the abortion ban doesn't violate EMTALA. The pause in Idaho's abortion law at the time, that was lifted through that lens. Until this morning, so another change. In a win for the Justice Department, the Biden administration, the Ninth Circuit Court has granted a rehearing en banc of the recent court order that said Idaho's abortion law is not preempted by federal EMTALA. So the district court injunction against Idaho law is back in effect for now. So we are back to where we were back on September 27th. Here's the official order from the court that came out this morning. Quote, upon the vote of a majority of non-recused active judges, it is ordered that this matter be reheard en banc pursuant to federal rule of appellate procedure. And you can see here that it says the order published there in September is vacated. So what's this French phrase we're talking about here? Well, en banc, and I'm sure I'm saying it wrong, it's a rehearing, and it means that a larger group of judges at the Ninth Circuit will be hearing the case instead of the smaller panel of 3 judges that ruled in late September. So very literally, en banc is a French term meaning on the bench, and the phrase is used to describe the special procedure where a larger group of judges of a particular court, like the Ninth Circuit, they hear a case all together. This happens in situations where a court thinks that a case is very complicated. They want to get more brains on the deal.